8 ebyo bintu kusasa yapanga na bipanga yabipangira ku kalenda nagamba tugende wa Jerusalem wa Kayanja kusasa batukana omuli amolo kunjagala okuza kusasa bati yapanga bipanga ebyo byoko
bipanga ne babimubako
ye ne babimubako bamubirage wa Kayanja ne bayingiza files okumwezi taliyo abaddayo oluguudo malaya baateka mu bana babwe bakolomota bakaza babatwalanga bakolomota file ne baziteka mu zifuna sente bali sima dio musajja oyo musime ku Jerusalem musale mu muntu njogera ko n'omwongera ka ifana bitakatonda ali waggulu era alaba kino kola kitufu kyakyo Bible gambo bera ku mazima n'ogabera ko omuntu omu nze ndiwe dokusigala ko ajali mu ziranzeka yes ne munagama nti yakwata mbisi I'm going to stand with ajali mu zira mbadde ku kitanda era nva nonzira yo ku kitanda musijja kunnuma mu bagame zibadde na billion n'injukulako yes zibadde na billion bagame mu kijja ko zifeke ngenda mu Kkooti because manchi njagala no malirivu abo manchi chendiko nwanire dembe lya basajja nwanira boy charity nakuli mera ko paka wa president kitompito kusala Wabon subira mbonja biko mya mwana nza abantu babanji n'abafe batunda nabo batakola bankuba kubanga tebana balabikira opposition yenkuba nze wonje alien skin osubira ntebani agenda okunjagala balina kunjogera ko bibi naye nze kyange nkituukiriza nkikoze nkimekinze nze okuba ne ngamba Jerusalem musane mu kubira omulanga ne president bayanguye alien bamukwate bamuteke ku side yawe kibi omulimu gwange gweguki omuvubuka alina command alina abantu bamuliramu bamulaba akuze nje buli kaseera abantu abalina redo okufana yi bwe mpita government nenji kowola ne Jerusalem mukowola nti omuvubuka mumulaba singa babamu naye gata ku Bobi Wine chechi nadda wano mwabira bako wano akanya omunye mubagayira Bobi Wine atufukira yoleke bamuteka mu sente Bobi Wine secretary TM muteka mu sente nemutwale kyadondo yamanyi muvubuka jako wampisa akolera abantu akolera industry music yagenda kubefuulira era wano abantu bafaako olwekwekalakasa kati singa walabe abana ba Allen nga bakuba ebyuma singa nabo bayingira politics nze sekisangala kyengamba jena kyanguyire kubanga jeno kifuisena ate alaba asobola okuwuliriza abaana munagamba mwagalacha temulina mirimu nti mulimu abana basobola okugenda mu maje mulimu abana basobola okugenda mu SFC mulimu abaana abalungi abategeevu abaana balamu abatwale babawa emirimu as simple as that mbeera mubi olambase koze mulimu gwange ekyo kinkubya nyo munangu nze nja kwetondera kitange kubanga bamugamba ebigambo ebikyamu ne Kkooti waliwo abaana babata Kampala jjani bampandikako ebigambo ebikyamu mbongambe mwana mwezi watata alien skin omulimu agenda kutuluzinga mbuno agenda kuba ku mulimu kunaku nabawawabira era nabashuulira fayiro etambula njagala bave bannumirize wannakyogerera bave bannumirize wannakolaki kubanga abantu bangi baziba kuba propaganda ate obuzibu tulina okutegeera si kwa buwaze bakuba propaganda era Jerusalem yakitegeereddewo oli yawandika n'okwandika ex advisor ng'alina ekigendererwa kati gwe oboolaba nsobola okugamba bwakalamba akalamba kaki obulambo bw'abayimbi kiddamu emirambo gy'abayimbi ne bapromota batasimba basajja mwete musime ku Jerusalem musale kyokka kyekimuluma njagala meseji yange mugitegeere bulungi nwanirira ddembe lya Jerusalem musale kulinyirirwa era Jerusalem evaayo ne muwa amagezi neŋŋamba nti jeno kenzi tajja kusobola kujja bayimbi muki wadde mukulembeze naye ate gwe bwewandiikira DPC n'owandikira RPC ne mmeya waggulu abantu abasobola okufuluma ekibuga kya ggulu ate kyekyagana na Jerusalem tekyeraga na jeno nkojo kati jeno Babalundi basobola okugikola ebyo okulagira bulagizi mmeya w'ekibuga ggulu okulagira RPC wa kibuga ggulu okulagira DPC wa ggulu n'abo abayimbi nga tebafuuka kizibu ggulu abantu abagenda okulaba Jerusalem basula mu akyoli ino era ya jeno otema abamanyi okitegera bulungi naye bano abantu bafuusa kirerezi omuntu nasula mu ggulu omwaka mulamba ekinuma kikino omuntu nasula mu ggulu omwaka mulamba jeno n'ava namusasulira lenti si abamusibyeyo kati weŋŋamba nti jeno aliko oluggulu lw'ekizibu kye bwe noŋŋamba ninamuvuye iziti kivumo kubanga omuntu asuuza omwaka mulamba jeno n'amuwa lenti n'alisasula n'amuwa ne sente nenkera nadda waliwo abantu bannamaliri babafuuka bazoba ne babbulooka be n'olaba omuntu mu mwezi gumu omulaba emirundi era n'omuwa sente ng'omulaba mu maaso go tomubuuza nti okola ddi wamma that is my road, that is my way. Bana abangaseke ebigamba abanvuma abankuba nza amwe lion amwe big more than big obo bulabiti bulina ku obujjonkezi bina kujjonkera jabukuba muka mairaga nze nakangu
agambye bwajja bakumuka Balwane content era content naye maama abakaba n'abeera mu makanza musooke muguleyo ku data awo mupiininga awo ennamba awo moderator pinning enamba awo
ate kuba ku moderator waaki sirugezigezi kikyakola
ayina pinning enamba
anti gwe moderator ate kati oli moderator byebi
wakati ndaba data
teekako enamba wano ogipinning
ndabe wano 0759529778 Thank you for update. 0759529778. Good morning to you, Bella. How are you? Bettina olimba. Yeetaaga abakozi naye abaana abali akuleesiibwa ati abaana bakulu bamanyi baagala byakufunirawo
luba lugendo mpola mpola start from one step ndesho kuna tikiti tuwe bakasanga
ekiro mba neebuzi
nga n'ekiro obwako
sibaako kiro
okakusanga
ekiro ennyo mbaako ssaawa
nya
oba 12 oba oluusi emu nengenda neneebaka paka ssaawa 12 naye kati omutwe gwakanya
ebimanyira naye nze sibisobola nade tiktok sigisobola
gwamanyira
buli yali yagala ajja omuwasa oyo ayambadde polisi
ajja muwasa
kisoboka yakoowa
nama etaata abatapinga screen mwebale nnyo naye tekeeko ne ssente Deshi after Kkooti, I want to see you. Oyagala kundabira wa ssebo mukama wange. You want to see me where? Duke obanga otya Council Duke osize otya wakedde ndi bulungi manager Roni wangoba naye happy new month manager Roni naye sooka onsindikire ku ssente munsindikire ku ssente okola ki mu kkooti noonya kontenti sente yo alina okubulookinga gwe tolina na DP oyo waniino oyogera bya kisiru genda mu mute sirani nagawo nyaga siha Kamaama ogamba otya kamaama badde embalaga ekiri ebweru namukasa ali bweru maama minisita leero bamuganya oyingira owaayi manageroni ogamba otya wali ntereddeko ku kusente Deshi, thank you. You are welcome dear. Musajja we abantu abali wabweru baweza omutwalo
kujjako mwogeramu nti Haji kiba ekimusuubirwamu si kyali nti ekyamuleeta wano sikakasa nti kyako sinzira betumumanyi kubeera nti tuwaayo obudde bwaffe okujja sisuubira nti kiba ekimuvunaano ekikola kizibu omuntu asobola n'okudda ku ludda olumu olw'okuba eno eriyo gwatandiitaasi nagamba nti wadde ali ku kituufu nesibira ku ludda n'oyo tubiraba mu bintu bingi naye nga nti omwanya kwange kumanyi omusajja oyo bayirakubaoyo nze ensonga zaabwe zaali zituseeko ewa mu musikiti gwaffe naye nga museezi tufe zaali zino si zino naye nga baayinako ensonga zaabwe era omukyala nazireetako ewaffe emyaka egiyise mukaawo omutonotono naye era twamaliriza tuba omusengeze nga tulaba tabe muntu mutuufu yayinza okugenda okufuna singa omuntu oyo takyusa mu mbeera ezo ekino olwaleero tetuliko katinzize ku muntu gwemumanyi mbeera za mukyala Case number 389 of 2024, Uganda vs. Alliance Jamal Alliance for Joy.
Please, your ship. I'm not aware that they are discussing this report. However, his legal representative is here. The circumstances, I pray that the accused, the matter be and production warrant. But his legal representative can also.
Your worship of Gilbert Waterman. Production warrant was issued. What's there? I do not understand why it was not enforced.
Prisoner, could he be in the cell also?
No, Your Worship.
Explanation there.
Your Worship, we have not them because of space, but they are in the cells.
On the cells?
Yes.
Councilman Abel, have you started with the matter or is it informed?
You want to split the matter is what? Yeah? You can get another day.
Yes, Your Worship.
You explain to me put you on record.
Your Worship, the reason we
I want you to identify yourself and I put your record as what you are telling court.
I am Cadet Police Officer Fred Kenya.
Fred who?
Kenya. Yes, Your Worship.
I want to see them report identity of.
Yes, Your Worship.
The other one I can't hear right.
Cadet Police Officer Frederick Kenya.
Bukenya.
Yes, Your Worship.
And then the explanation that the inmate is a file with the court cell. In the cell that court.
Let me confirm, Your Worship.
You have been hard.
You are confirming, Your Worship.
You have the inmate produced on 19th of December. What has done that? It's not convenient, you know. Friday, 24 night. Is the working a Friday? But we also have this in May and June.
Next year.
What? They're not allowed. You have 14th? Look at your 14th of January, cancel. We meet next year.
Application number 408, 2024, Mzerwa Ali versus Uganda.
Whoever is that person reporting this matter should be what we have and
Most of that. May I please you, Your Worship, provide about two. I'm appearing jointly with the Honorable Hamadi Serebo, Mr. Bima Jamil, Kaluwa Eno, Kapinju Ayeru, and Awero Susan, Awero Sarah. Excuse me, Your Worship, I know you Papa Susan, but her name is Awero Sarah. My Lord, Mr. Amarit Timothy. Most of them. My Lord, my name has been murdered, so I prefer to give it life. Yes.
All the technical authorities. Proceed.
Most of life. My Lord, my name is Timothy Amerit. I am the Honorable Senior State Attorney in the office of the DPP. I appear together with Counsel Zubed and Namugirwan. Namugeni. I beg your pardon. Counsel Zubed and Namugeni. From Sania Namugirwan Company and Reports. My Lord, the applicant is in court, and this matter was coming up for hearing by the learned judge. In his absence, my Lord, I prefer another date. Your Worship, we've appeared in this matter several times. The first time we appeared in this court, Your Worship, the court gave us directives. Those directives were to the effect that the applicant will file submissions.
Now, let us proceed in this matter. The history of the matter is known even in the Constitution.
Most of them.
And we are saying file submission.
Yes.
Which is clear and all parties. Now, I want to give instructions as to how we should proceed as guided.
Your Worship, we are going to move you under that particular provision of the law, but if you're giving us directives, most of them.
The LINKUP judge indeed not available this morning, but he has given directives that we have the suites identified and any other matter shall proceed. So That is the question, and that's how we're going to proceed.
Your Worship, could we add that on the issue of identification of sureties, we could also highlight, since it's for purposes of receiving?
No. Highlighting of submissions?
Highlighting just a few segments of the...
I'm not at all in that respect. I want to clear to take from particulars of the sureties period. Those are the instructions, and that's where the legal mandates.
On that note, Your Worship, then we will move to identify the legal surety as directed by the judge. Your Honor,
That's what.
yes, Timothy Merit. Yes, Your Honor. We appreciate the information that we have received. I need, however, to bring to this honorable court the fact that the hearing of this matter is not an issue of convenience, but one of law. And I've well noted that this honorable court will not take on the hearing of the submissions, which perhaps will be done later. Your Honor, that in my view can subsequently be done with the identification of the sureties in the subsequent sitting. Your Honor, under Section 15 of the Trial and Indictment Act, it governs the hearing. Section 15 of the Trial and Indictment Act governs the hearing of a bail application and release of the accused person on bail. And it clearly states that that mandate is squarely of the High Court, and in this instance, the judge sitting as the High Court. The consideration of bail application, Your Honor, consideration of a bail application, Your Honor, includes one, the applicant lodging the application, the respective counsel either divine being heard on the application, the sureties being identified by the court, and certainly the subsequent determination of the application. Your Honor, the law requires that such undertaking be handled by the judge of the High Court. Your Honor, that undertaking cannot be delegated to a registrar or to any other officer of court. It's squarely a mandate of the judge, and that maintains the integrity of the proceedings. Your Honor, in the Constitution Bail Guidelines, for courts of judicature, practice direction, of 2022, particularly rule number 3C, 3D, they require the court 3C, 3D.
Yes. If you don't say and, I presume there are so many. 3C and D or 3C? Continue.
Your Honor, I hope to adopt those two, 3C and 3D.
Correct.
They necessitate the court to promote uniformity and consistency. To promote uniformity and consistency when considering bail applications. And Your Honor, this is not exclusive to the determination of the bail application. But it refers to the entire process, right from lodgement of the application what transpires in the course of the application, and final determination. And D requires there is a need to streamline disparities in handling bail application. Streamline disparities. Actually, it says streamline and address disparities in the handling of bail applications. Your Honor, the position of the law and practice is that a judge entertains the bail application throughout. Including identification of sureties. The issue of having a registrar receive particulars of sureties is a disparity. In the handling of bail applications. And there is no law that permits a registrar to have that power and mandate. Your Honor, I'm well aware that Section 43(2) of the Judicature Act, Section 43(2) of the Judicature Act provides that where there is no procedure laid out for the High Court in any written law, where there is no procedure laid down for the High Court by any written law or practice, the court may, in its own discretion, adopt a procedure justifiable by the circumstances of the case. That's what that provision says. This provision refers to the High Court sitting and a matter of procedure arises and the law is not clear to that judicial officer. Then that High Court judge will then, in his seat, exercise discretion as the circumstances of the case warrant.
Just put it clear that we are in the I'm sitting in the chief of court.
My Lord, I prefer using my words, and I do not want to put words in my mouth. We can say you're seated in a court of religious track, simply put. So, my Lord, Your Honor, the High Court is the one to make that determination in a matter of procedure. Now, receiving sureties in the instant case is not a matter of procedure. And it is not even the High Court receiving the sureties, exercising that mandate in itself. It's not the High Court, it's not a sitting judge. Because it is the sitting judge, the High Court, to exercise that right and power. I need not overemphasize, Your Honor, that matters of jurisdiction are creatures of statute. Matter of jurisdiction is a creature of statute and cannot be delegated, not even by an order of court. Matter of jurisdiction is a creature of statute and it's not delegable or cannot be delegated, not even by an order of court. That would be an illegality. It's like a High Court telling the Chief Magistrate handle a murder case. It's an illegality, ab initio. I would wish to draw court's attention to the case of Uganda Revenue Authority. Uganda Revenue Authority versus Rabo Enterprises Limited, Supreme Court Civil Appeal number 12 of 2004, where the Honorable Justice Lillian Tibatemwa Echirikubinza stated that where a court held, I beg your pardon, yes, where the court held that registrars cannot exercise jurisdiction beyond their express legal mandates. Your Honor, I don't see you writing. I pray it's captured even in your report.
Instantly, I asked if on the microphone. It's not out of the blue. For a reason. that you are being captured verbatim.
Most obliged. I hope this except is not expanded. But it says, the court said, where the court held that registrars cannot exercise jurisdiction beyond their express legal mandate. The effect of this decision, and my Lord, Your Honor, I'll furnish court with a copy of the decision. At the rise of court. It's there online. Your Honor, it's online, so you can check it out. It's online. Your Honor, the IT specialist can confirm that there is internet in court right now. Proceed. Most obliged. The judgment emphasized that any action taken by a registrar outside his or her bounds is null and void ab initio. And I already stated that not even an order of court can confer delegated powers. To that note, Your Honor, I appreciate your expressed desire to hear the sureties. I really appreciate. This matter has been adjourned severally, like counsel said. But in the interest of maintaining the integrity and legitimacy of these proceedings, it is in order that the law be followed. I beg your pardon.
I appreciate the express desire that I have express desire by the registrar. So I'm not acting under instruction, but I think it's my desire.
Your Honor, if you have, you can borrow me a better word.
The court.
How did you rephrase? I'm trying to think. But I appreciate the express, your availability. I could use the word availability.
It's the court.
You know, I would wish to distinguish the court, the judge, and the court, the registrar. Because that's now where the gist of the discussion is. I said this respectfully, Your Honor. I'm not trying to. I'm just concluding my prayers so that we get into. Yes, like I said, I appreciate the express availability of you, the Honorable Registrar, to receive the particulars of the sureties in this matter. However, in the interest of maintaining the integrity of these proceedings and legitimacy of the application that has been filed by the applicant, it is only in the interest of justice that either the matter is adjourned until the availability of the judge to entertain it, or recourse can be sought from the head of the division or any supervisor to have this matter reallocated and heard by any judicial officer who is available. Otherwise, we shall suffer a fate, the applicant will suffer a fate where several applications will arise to be determined, pending even the determination of his own bail application in regard to the legitimacy of the proceedings. It is the applicant that will suffer. I really want this matter disposed of as quickly as yesterday, but in the right way. In the right way. I so pray, Your Honor. She associates with my submissions. Maybe the clerk can first reiterate what I was saying before counsel stands to the applicant. We do it.
The applicant is duly represented by 6 lawyers. That should not be his worry. Your Worship, first and foremost, I am baffled by submissions of my land council and land state attorney, senior state attorney. Firstly, to note, Your Worship, is that the court is not making a determination in this matter. The court is not sitting to determine the matter. Those are very key, important issues to note. The court has specifically stated that it is here to receive on the sureties for identification as directed by the trial judge. Your Worship, I want the court to note trial judge. The trial judge is every known in this matter. And my land friend has considered every that the trial judge gave directives. Unfortunately, is not here either on health grounds or other grounds, and has issued a directive to that effect. It's unfortunate, it's baffling that my land senior state attorney, who has practiced before this court, cannot appreciate the administrative nature of these courts. Your Worship, the land senior state attorney has stated that section 15 of the TIA enjoins the court to hear bail applications in the High Court by a judge. We do agree that that is the position. However, Your Worship, you're not sitting. In fact, the courts, as near as possible, have always adopted a procedure under section 14, 2C of the Judicature Act, in as far as section 14, 2C of the Judicature Act. In circumstances where there is no proper procedure and the court is enjoined to promote good.
Can you read the section?
Most of it.
No, I think let's use off the microphone.
That section, Your Worship, is to the effect that where there are no express law or rule is applicable to any matter in issue before the High Court, in conformity with the principles of justice, equity, and good conscience, the court is enjoined to adopt a procedure that aims at promoting equity and good conscience. Your Worship, the directive by the land trial judge is in conformity with this particular provision. And indeed, Your Worship, it has been a practice of this court where the court, under that particular provision of the law, directs the registrars to either identify or receive passports in case a bail application has been concluded, or enforce the directives of the land trial judge. It is in conformity with that particular provision. Your Worship, it is a fortified submission that you are ably in charge of the directive of the land trial judge. You're not sitting as a court to hear the bail application. And indeed, as the land state attorney has stated, section 43(2), equally enjoins this court to give such directives in order to achieve the ends of justice. Your Worship, the land state attorney has relied on the case of Bravo Enterprises to claim that this is a matter where you're sitting as a registrar to hear the matter. We disagree first and foremost. In the Bravo Enterprises case, Your Worship, the registrar entertained certain matters when he did not have jurisdiction. He had determined, and the Supreme Court is not a matter where the court is hearing. This is not the matter where the court is saying the sureties are substantial. That is not there. The submissions of my land state attorney should have arisen at the time of an appeal, in case he wants to appeal, that you entertain. Your Worship, it is on that ground that we invite you to proceed and entertain the receipt of the sureties. My land colleague, Ms. has something to say.
May it please Your Worship, I would like to emphasize section 43(2) and read it in verbatim, that talks about officers of court, and it states as follows. Section 43(2) of the Judicature Act. 43. Subject to Article 133 of the Constitution, the officers of courts of judicature shall perform such duties as may be assigned to them under the rules of court, and shall be subject to general direction and supervision. And also 43(1) states that there shall be such officers of courts of judicature as may be necessary in performance of any such special duties in connection with the business of courts of judicature. And such officers may include the chief registrar, registrar's deputy, etc. Your Worship, when we are here, states can also attest. Just a second.
I just want to keep clarity. The provision is reading. I want to ensure that we are in sync of the provision, because the 43 is reading is not the 43 I see in the 7th revised edition. They just wanted to be maybe clarifying that. We seem to be reading different laws.
it's clear here that where in any case no procedure is laid down for High Court by any written law or by practice.
Council, what section are you reading? Because you are already want to ascertain.
Section 43
Of the laws it is.
of the laws it is, Your Worship. And in any case, Your Worship, my learned colleague clearly stated that this court has adopted a practice in applications, and would like to say that you're seated here as court, not in your own capacity or from your own volition. And you stated that immediately you had entered. Your Worship, you clearly stated that you're here to identify. In any case, we already made submissions that you clearly stated were already a record of court. And they associate themselves to those submissions because they have theirs in reply. Meaning, Your Worship, that even a mere giving of date, he will object because you're not, in his opinion, the trial judge. And he would say that that would be a fault in procedure by his own assertion and submission. In our opinion, Your Worship, you're here in the rightful capacity, and we invite you to perform your duty as assigned to you as court. Most obliged.
Maybe, Your Worship, just one thing, because the land state actually relied on Bravo Enterprises versus URA. Your Honor, first and foremost, of course, that was equally civil case, but this court equally is enjoined under Order 51 of the Civil Procedure Rules to entertain interlocutory application. Your Worship, we are not saying you're entertaining an interlocutory application, but this is an interlocutory application that you are equally mandated under Order 51 of the Civil Procedure Rules to entertain. Because this is a bail application arising out of the main case. So, Your Honor,
I don't want you to wait us, just to go elsewhere.
most of them. So, Your Honor, it is our submission that just like how the court gives directives to you to adjourn matters, these directives are in sync with you to receive the sureties as the court has decided. The trial judge has not divested himself of the powers to entertain and determine the application for bail. That one is not anywhere in the court. Secondly, the trial judge has not directed you to determine the substantiality of the witness, of the sureties. The trial judge's directives are very clear. Receive the sureties. And Your Honor, that is a noble duty that everybody should be in the position to appreciate. First and foremost, the documents are already on record. In regards to the sureties, the land state attorney replied to those documents. What is here is specifically to identify the sureties that the court has never had occasion to look at.
Can we have the joiner?
Your Worship, if you so wishes, but I don't think that it has them.
Most obliged, Your Honor. I begin with the submission that this Honorable Court under Order 51 of the Civil Procedure Act has powers to entertain this application. Your Honor, it was on record. I prayed to make response.
Don't play court, so it is not going to play court.
Your Honor, this matter has been captured on the record.
And it has been captured that is very important in certain establishment.
Your Honor, I don't mind that you don't report it, but I pray that I still bring it up. Most obliged. My brothers submitted that this Honorable Court, by Order 51 of the Civil Procedure Act, has the powers to entertain this application.
That's not what he said, but say interrupted application and he was referring that this is an interrupted application. Okay?
My Lord, it's actually the same argument.
The same argument. It is overruled that this court cannot entertain interrupted application on criminal matters. Proceed. I am with your application.
And on that overruling, on that ruling, this is an interlocutory application. A bail application is an interlocutory application. And as court has rightly ruled that it does not have power to entertain, sure, it does not, and I agree with it. My brother has continued to submit that the court as it sits now is merely hearing the application, not determining the application.
But that's not what is on record.
Your Honor, they said
The court is receiving, Your Honor.
the record is clear. We can always get a certified copy later, and we shall know what each person said. So my brother has argued that this court is merely hearing, not determining. And he further stated that the court is merely hearing from the sureties who are already on record. How can court determine if in the first place there was no hearing? You know, just the thought of it doesn't make any sense. By this court as it's sitting, receiving the particulars of the sureties in the record, that in itself amounts to hearing. Whether it determines the application or not is something else. And that is the integrity of this application that we seek to have maintained. The entire process of it. By hearing the sureties, getting their name, getting their residence, getting their phone number, getting their national ID details, that in itself is tainting the application in its entirety. And we want to arrest that abuse. And there is no doubt, once an illegality is brought to the attention of court, court must not close its eyes to it. My senior brother, the Honorable Sereko, said that I had said, and I wrote it verbatim, that I had said that this court has in the past adopted the practice in applications. I did not make that submissions, far from it. And there is no practice I brought to the attention of court that has been adopted before. You know that there is a very big difference between a registrar appearing in a matter such as this and adjourning, then appearing in a matter as this and receiving particulars of sureties. When a registrar sits and adjourns the matter, the registrar is not hearing the matter. But when he goes ahead to entertain and get information that informs the determination of the application, that is a hearing of the matter. which cannot be tolerated by this honorable court. A section was read, section 14(2)(c). And I would first want to read it verbatim and I make an explanation thereafter. So section 14(2) says, subject to the Constitution and this Act, the jurisdiction of the High Court shall be exercised A, in conformity with written law, including any other law in force. Then when we jump to C, where no express law or rule is applicable in any matter, in issue before the High Court, in conformity with the principles of justice, equity, and good conscience. No express law or rule is applicable in a matter, in issue before the High Court. When the law says before the High Court, it is talking about before a judicial officer entertaining, lawfully authorized to entertain the matter. The High Court is not seated here. It's not. We cannot say these proceedings are proceedings of the High Court. They aren't. As far as this provision is concerned. So this refers to the High Court sitting. And it says that the principles of justice, equity, and good conscience. What does justice require? What does equity require? What does good conscience require in the instant case? What does it require? What does justice require? The man is rotting in prison, he needs to come out. But we are not going to illegitimize his application. He needs to come out. And I'm okay with him coming out, but in a proper way. So what does justice require? What does equity require? What does good conscience require? In a division like this, where there are other judicial officers, what is too hard with another judicial officer today hearing this matter, one authorized by law, today? That would be justice, that would be equity, that would be good conscience. What is too hard with that? Let Mwizera have his day before a judge and have his application determined. My Lord, you know, counsel, you are not going to divert me. I am responding to section.
It should be restricted to what we stated.
I'm responding to section 14(2)(c), and that is what was raised.
Your worship, we need some more dimensions.
My brother, please do not distract me. For your record, I cannot be distracted. For your record. Most obliged. And I request my brother, receive some people.
When he raises the cup, take a seat.
And being senior to him, you should really respect him.
And when he stands, you sit down.
So my brother, it's my day. What does the principles of justice require? What do the principles of equity require? What do the principles of good conscience require? Under the instant case, where even the registrar wants to receive particulars of sureties, but cannot go further to hear anything further than that. What is justice? When we are going to adjourn the matter, then when a person who can entertain it comes and you see, think about it. Your Honor, it is my duty as a Minister of Justice to make sure that any illegality, whether it works on my behalf or against my behalf, it is my duty to make sure that it is arrested at the earliest opportune time. And I submit that, Your Honor, the best that this court right now can do is either adjourn this matter till a judicial officer that is authorized appears to handle, or, Your Honor, seek supervisory intervention to have this matter reallocated before any other judge today, and we have this matter disposed of today. I retaliate my earlier prayers.
side. And not critically the concerns of the prosecution as read by Senior State Attorney Americ North. Americ